Good morning, everybody, and welcome to this edition of Macro Pro and Friends. We had a little bit of technical difficulty, so we're starting a few minutes late. But I have a few housekeeping items before we get on with the webinar. So, James, if you'd switch the slide, please. All right, a few things that you should know. First of all, your certificate will be coming to you via email. It'll arrive tomorrow. Say your certificate has arrived. There'll be a little blue button. So if you would click onto the little blue button, you'll be able to download your certificate. If for some reason you have difficulties with that, please email me your original email and I will download that for you and send it back to you. If you would like to ask James any questions today, since we're doing a legal update, there is a question box. So please put your questions into that box, and at the end of the program, if there's time, I will be happy to read those to him. And then lastly, there are handouts for today's program. So if you would like to download them now, that would be fantastic, and that way you can have them to refer to during the program. So today we have James Rossi with us from Rossi Law Group. Hi James, how are you doing?
Well, other than the technical difficulties, I'm doing great.
All right, well, we are getting a double signal from you, so I'm thinking maybe you can talk without your headset to the audience, and then just when you and I are speaking, put your headsets on.
All right, let's try this. How does that fix it?
That does. All right, we'll have a great presentation, and we'll see you guys all in about 50 minutes.
All right, thank you. All right, so today we're going to do a 2021 case law update. And then let me get rid of this here. So this is going to be a little bit different than case law updates that you guys have seen in the past. Essentially, when you get case law updates, people will give you an update as to certain cases that have come down, but oftentimes you may not know what it actually means. Is it a persuasive case? Who issued the opinion? How important is it? Do I need to follow it? Do my attorneys need to follow it? Things of that nature. So what I'm actually going to do is two parts when it comes to this seminar. The first part is going to be to explain to you the levels of the courts, the types of decisions that are issued, the persuasive value of those decisions, so that you understand when you see a new case come down the pipe, what does it mean? What role does it play with respect to how you interpret it and what it means? So after we do that, then we're going to go into some updates in terms of cases that have come down in recent, say 2020, and in fact one that's even come down already in 2021. So you're going to kind of get a double dose. I hope you find it interesting. I personally love this stuff. I'm a bit of a nerd when it comes to this kind of thing. I have had some experience doing appellate work in the Court of Appeals in California as well as the federal courts, and so I haven't had it in a while and I miss it. But that's what I used to do earlier in my career. Had a case go up to petition to the Supreme Court of the United States, and it's just something that I've always been extremely interested in. And then comp came and somehow sucked me in, so I don't get to really do much of it, but what I'm going to be talking about is still it's very relevant, and it is in line with appellate work. So the first thing I'm going to do is talk about the California Constitution. Basically, it gives the power to create the work comp system as a whole. So everything is derived from the California Constitution. All statutes, all court decisions, everything has to be consistent with the California Constitution. The next is the California Supreme Court. This is the highest court in the land in California. Obviously, there's higher in a sense of federal courts. You could have conflicts between multiple states, and then it goes to the California or the United States Supreme Court. But we don't ever see that in work comp. I've personally never seen it. It's something that's rare. So really, this is kind of the Supreme Court, the highest court for what we're going to deal with in California, unless you're dealing with federal cases, which I've never personally handled federal cases in workers' compensation. and I doubt that many of you have. So we're just going to stick to California. Now, importantly, anything that the Supreme Court issues is binding on the appeals board and the appellate court. So that's a very important decision when it comes from the Supreme Court. The level below the Supreme Court is the California Court of Appeal. And there are different kinds of opinions that are issued by the California Court of Appeal. The first is a certified opinion, and it's citable and binding on the appeals board and the judges. These are very important decisions. Then there's unpublished opinions, and these are actually decisions that are certified not to be published. So as attorneys, we're not really supposed to cite to them. Every now and then it could become relevant, but you have to point out to the court that it's an unpublished case, or you could get in trouble for misleading. But if it's unpublished, I usually just look at it to get information for arguments that can help on my specific case, but not necessarily to use it as any kind of persuasive authority. Then the third type of opinion is a writ denied opinion. And this is what you see most of the time. These are essentially, they don't even accept, you do a writ to the appellate court and they just don't accept it and they summarily deny it. And it doesn't mean that they don't agree. It just means that they're not going to make a decision. And these don't have much weight. They're not really controlling. Strike that. They aren't controlling, but they do have significant weight. So we will rely on these. Then there's statutory authority, and these are passed by the legislature. So for example, we had the 3 code sections that came down from the legislature pertaining to the presumptions for COVID. Those were done by the legislature, and those can only be invalidated if they're found to be unconstitutional, and they can obviously be amended and repealed, and that happens all the time. Then we've got the California Code of Regulations. And that's actually, it's about 700 pages. And it's got, so I think you guys can probably see this, but that's the Code of Regulations, double-sided. And all this does is it fills in the holes for the labor code. And it's rules that we have to abide by in terms of how to do things in the appeals board. There's even a code section pertaining to dismissing cases for failure to prosecute. That's in there. And they'll supplement the labor code by having public hearings that will, both sides, people will argue for and against these changes. It's not enacted by the legislature, but they do have the full force and effect of laws as long as they don't contradict the labor code. All right, so next we've got the California Workers' Compensation System. This is basically the tiers. So you start at the local district office. This is where I spend most of my days, or used to before COVID. But this, Van Nuys Board, Los Angeles Board, all the various district offices, this is where we have hearings and trials. Then you go to the next level, which is the appeals board, and that's where you get decisions, panel decisions based on a petition for reconsideration or removal. Then after that is exhausted, then it's the California Appellate Court. And then lastly, it's the California Supreme Court. So the most common decision is going to be a decision of a local judge. These decisions may provide guidance as to what that judge thinks, but they're not binding precedent. They reflect only the position of that judge. So every now and then we'll have an issue that is before a judge and we're able to find a copy of one of their decisions on that issue. And then you kind of know how they see it. But that's really all it's good for, is to help you understand what that particular judge will do and maybe give you some good arguments. Maybe they make a good argument that you can use, even though it's not something that you're going to be able to use as a binding precedent. So we've got the appeals process. There's pretrial and trial level. To appeal a decision made before the case is submitted, that's when you file a petition removal. And that can be a discovery issue, whether to set for trial, things of that nature. Then once a case is submitted, and the record's closed for evidence, then you would file a petition for reconsideration once that opinion has been issued, if you disagree with it, of course. So you've got a final order versus a non-final. Final orders is a reconsideration. You'll file for reconsideration to appeal it. And an interim order, you'll file for removal. So a final order determines a substantive right, and it can be AOE, COE, whether an injury occurred. It can be the statute of limitations. It's a final decision, essentially, and it disposes of an issue, in the case, a threshold issue, and so it's considered final. Whereas an interim order is something like, whether the trial should have been continued, whether the trial should have gone forward, the discovery issues, disapproving the set aside of a STIP, suspending CNRs, things of that nature. When you have a problem with those, then you'll file for removal. Now, what we do typically is, sometimes it can be murky as to whether you should file for reconsideration or removal, because you don't want to file for reconsideration and then the board says, well, this was supposed to be a petition for removal, so we're going to deny it. You didn't do the right petition. So what we'll do is we'll say that it's a petition for reconsideration, or in the alternative, removal. And that gets around that. And then they'll decide that issue for you. So the first kind of real decision is going to be a panel decision. So once you've got a petition for recon or removal, the WCAB will assign the case to a panel of 3 commissioners. And at that point, they will make a decision on the case, and they can either affirm, rescind, alter, or amend the order. And they can even annul it and replace it with their own. And it's going to be three members of the panel. And these panel decisions, once issued, they're not binding. They're admissible. Like, we'll cite to them. We'll provide them at trial a copy of the case. We definitely use them. They're important, but they're not binding. And we can make arguments inconsistent with those panel decisions until they become binding through a higher level court. These opinions are published sometimes in the CCCs or the CWCRs, and the unpublished opinions are typically not known. Then there's what's called a significant panel decision. And I'm sure you guys have heard of those. I think in 2020, I don't think there were any. I think that 2020 had 0 significant panel decisions, which is, I think it's pretty rare. It's, they don't issue a lot of significant panel decisions, but every now and then they do. In fact, we've got one already this year. These cases, you would think, sound binding, but they're not. They are just cases that the board feels are very significant and that they need to be disseminated to the community. And what they do is they get assigned to the 3 members, and then the members, they see that it's a big issue, and so they'll then get all of the members involved. So if it's a panel of 7, then all 7 will review it, and they agree that it should be declared a significant panel decision so that the community has that information so that they can follow their rule. But again, not binding. So I suspect a lot of people think that they are binding, but they're not. Next is a en banc decision. So this is where the entire group of 7 commissioners sit to decide a case to achieve a uniformity or consider a case presenting novel issues. And there were actually quite a few of these last year due to COVID. I think there were 10 or 11 en bancs last year, and maybe 9 of them or 8 of them were COVID related. So we saw quite a slew of those last year. These do have a binding force on future panels and WCJs. So anytime the commissioners are assigned to a case, three members assigned to a case, they have to follow an en banc decision. They can't go against it. With that said, en banc decisions are not binding on the California Court of Appeals. So you can still appeal a WCAB en banc decision if it's against you and you don't like it. These are followed unless the California Court of Appeal overrules the decision. And the California Appellate Court will generally defer to the WCAB unless it was clearly erroneous. It needs to be pretty egregious for them to step in and undo what the WCAB did. So when you have a petition for a writ of review, it's going to be reviewed by 3 justices in the appropriate district court of the Court of Appeals of California. This is the mechanism that we have available once we've exhausted our remedy or our means in the WCAB level. So once we've done a petition for recon and there's a panel decision or significant or an en banc decision, then we can challenge that by filing a writ of review with the Court of Appeals. The thing is, with the Court of Appeals in workers' comp, we don't get an automatic right of appeal. All we get to do is file a writ, and they don't have to hear the case. They can just reject it. They can summarily deny it and give you no reasoning whatsoever, and they have no duty. They're only going to take cases that they feel are important enough to justify using their time to do it. So it's unfortunate, but at the same time, whereas a civil case, when you've got a civil case and you want to appeal, you file a motion or a appeal in the Court of Appeals, and you get oral argument, you get to brief, you get to do it all. They have to issue an opinion on it. So you've got a full right of appeal. It's similar to what we have at the panel level, the appeals board level. And so we kind of have an extra step, because then we do an appeal in the WCAB and then we get to try a writ as well. Whereas in a civil case, they go straight to the appellate court and they don't have that intermediate level. So, but again, they get it all decided and they get a full opinion with oral argument. So most of the cases that we file writs on are just summarily denied. We don't get anywhere with it. It's pretty rare that they take them, but they do take them, obviously, and then they set precedent and they become binding precedent on us that we've got to follow and cite to in our pleadings, etc. Now, if they do, let me go back. If they do accept your case, your writ, then typically what they'll do is they'll set a briefing schedule and oral argument. And then your final remedy is going to the California Supreme Court. So if your writ in the Court of Appeal was denied, you just better bet you're not even going to want to waste your time trying to get a writ accepted in the Supreme Court, because they take very little. 7 justices have to hear gigantic issues on everything, things that are much bigger than workers' comp typically. And so only our most significant, biggest issues are accepted by the Supreme Court. It's very rare. I personally, in workers' comp, I've never even petitioned to the California Supreme Court, because there's never really been a case where it made sense to do so. Although with that said, we do have a case where the Supreme Court accepted it. We're working with this, it's a civil and a work comp. And if the civil case gets dismissed, then the work comp case is likely going to get dismissed because it's all the same issues. But this case was accepted by the Supreme Court, and it was briefed about 3 years ago, and we still have not even been set for oral argument. So if you do get accepted by the California Supreme Court, be careful what you wish for, because it may just be a big, long delay. All right, so now what we're going to do is we're going to talk about some cases. This is, you understand now the different types of cases that there are, the panel decisions, the significant panel decisions, the en banc, the Court of Appeals, and then the Supreme Court. And then obviously we do have to follow the labor code and the CCRs. So it's important to know who's issuing the case, what type of case it is, so that you can determine whether you have to follow it. So this first case is Corona versus California Walls, and it pertains to temporary disability benefits during quarantine. The issue was whether the applicant was entitled to temporary disability benefits when out of work due to the quarantine order. So the applicant in this case had an injury, was working modified duty, and then the stay-at-home order was issued, and so the employer had to shut down and send all the employees home to comply with the order. And this included people that didn't have work injuries, the people that did have work injuries that were working modified duty. It was the whole company shut down. The whole industry shut down, not even just the company. And so thereafter, the applicant received no wages for a couple of months, and he got no COVID-19 benefits. And so the applicant was claiming entitlement to TTD, claiming that it was the employer was not accommodating modified work. The court held the applicant was entitled to temporary disability benefits. The reasoning was that the employer's inability to accommodate work restrictions does not relieve its obligation to pay benefits. To avoid liability, the employer must prove it terminated applicant for cause. When neither party is at fault for the loss, then the employer should bear the loss, is what the court decided, which to me, I disagree with it. And I read the case, and essentially there were arguments that weren't made that I would have made. And again, this, just so you know, this is not a binding decision, because the case was a panel decision only, and therefore it's something that you can still argue that this case essentially has no binding effect on you, and you can make all your arguments. So my argument would be that it's a non-industrial pandemic that caused it. The employer was accommodating all along, but for a non-industrial pandemic that impacted everybody, whether you were injured or not. And so therefore, since there's no way you could do that job because the whole industry was shut down by the order, then you really have no wage loss. So it's a wage loss analysis, and this case never touched any of that. And there's a line of cases that are very favorable to that argument. So this is not binding. We would, if we had another case like it, we could still make all of the arguments we want to make. Then came Sabalis versus Trimark Chef Toys, and this one takes it even further. I disagree with this one more than I disagreed with the last one. And the issue in this case was whether applicant was entitled to temporary disability benefits when they refused modified work due to the fear of COVID-19. So here, the applicant had an injury, and he was TPD, temporary partially disabled, and he was working part-time in a food service. Ultimately, he had two jobs, and he quit the other job, which was at a Starbucks, because he was worried about catching COVID-19. He basically felt like working at Starbucks put him at risk, such a high risk that he was afraid to do the job. And the defendant argued that the TD benefits should be reduced by the wages because the applicant refused to actually do the work. He would have otherwise had a job. The court held the applicant is entitled to temporary disability benefits. They indicated that defendant didn't meet its burden of showing applicant unreasonably left their job due to their own misconduct, and the WCAB held that declining a position due to COVID-19 fears does not constitute an unreasonable refusal to accept the modified work. So essentially what they decided was that this was a reasonable fear, that working at Starbucks was a high-risk position, and so the applicant not wanting to do that job was reasonable, and therefore he should be entitled to TTD. I personally don't agree with this opinion. I will say that the judge that issued it's Judge Dobrin in LA, I find him to be a very smart, thoughtful, reasonable judge. And so But when I read the opinion, it seemed to me like he was really trying to support his decision. And he did make some solid arguments. I'm not going to say he did, because he did. But with that said, this was completely up to the applicant to decline to work for a COVID fear. And it has everything to do with the non-industrial pandemic, not the industrial injury. The industrial injury had nothing to do with him not working, absolutely nothing. So I don't agree with this. And I think that, like I said earlier, there's a long line of cases that gives you an argument that there's no wage loss due to the industrial injury, and therefore it should not have been a period of TTD that the applicant should have been entitled to. It should have been reduced by the amount that he could have worked doing the job that he quit. Next case. This one is also I think this was a panel decision, yes. So this one also is not binding. And it pertains to temporary disability benefits when someone is undocumented. And the issue is whether applicant was entitled to temporary disability benefits when out of work due to undocumented status. Here, the applicant was working modified duty for 7 months, and the employer determined the applicant was ineligible to work in the United States because he was undocumented. The employer then terminated the applicant due to the undocumented status. And correctly so, the court held that the applicant was not entitled to TTD benefits. And the argument was that modified work would have been available, but for ineligibility. And it was deemed credible because the employer accommodated the work restrictions until it discovered the undocumented status. The decision was upheld, and the reason the applicant could no longer perform the job was not due to his injury, but in fact due to his work eligibility. So this is actually a very sound decision, and I would agree with it. But again, it's just a panel decision, so it's not binding, but it certainly has some persuasive value. Next, we've got true height. This pertains to telephonic trials. Now, this occurred in 9/4/2020. It was a panel decision, so it's not binding. The issue was whether the WCJ had discretion to prohibit a trial proceeding telephonically. So we had a case where the telephonic trials were allowed by the DWC. They had issued a memo, a newsline memo, and it permitted telephonic trials. But in this particular case, the matter was set for a telephonic trial on AOE COE during the stay home order. And video conference was not an option. It was actually going to be an option, I think, on September 20 something. So it was pretty close in time to video conferencing being available. But the defendants objected to the trial proceeding telephonically, and the judge agreed. The applicant wanted to move this case and was not happy at all about the continuance, and so they petitioned for removal. So this wasn't recon, this was removal, because it wasn't an appeal of a final order, it was an appeal of getting the case to go to trial. The holding was that the judge could use their discretion to forego telephonic trials. The reasoning was that work comp judges have to determine credibility of witnesses, and to do so, they need to observe the demeanor. The court indicated it is virtually impossible to determine credibility using telephone audio alone, which I completely agree with, and that the judges have discretion to continue trials to include live testimony. Now, we actually had a case similar to this, probably around the same time, where we were being forced to go to trial, and it was a big time credibility issue. We even had surveillance that was going to be shown to the applicant and prior injuries, and it was a huge case, and we absolutely objected to having a telephone trial on this issue. And so we in fact objected, and the applicant attorney was pushing. They wanted to get it going. And the judge ultimately said, I'm going to give a continuance and we're going to do it on video. So I think it was about 30 days. He gave us about 30 days to come back and do a video trial so that the judge could see, how an applicant answered the questions. And my concern at the time was, if I've got an applicant who's in his home or wherever he is, I don't know what he's looking at. There's a camera there, but what's behind the camera? Is there somebody coaching him? Are there notes being provided on a computer? I have no idea. And so that's something that I always felt was a little discomforting. And ultimately, though, I've changed my opinion on it because I've decided that we need to be able to move these cases. If we're not willing to do video depots at a time when there are no in-person trials, and who knows when they're going to start back up, then we're going to have a lot of clients that are upset because their cases aren't moving, or B, you're going to have applicants upset because they're not getting their benefits. So we really have no choice but to make the sacrifice and do a video trial. So I'm not opposed to it like I was. I've changed, and I've seen that it actually can work. The video has worked pretty well, other than today where I'm having some technical difficulties. Typically, all of our depots and hearings have gone well, very well. So I'm okay with it at this point. But the judge was given the authority to use their discretion to forego the telephonic trial and have live testimony. Then came Gal versus Chevron Corp. And this is an en banc decision. So this is binding. And this just came down on January 12th of this year. And the issue was, should trials proceed remotely or be continued indefinitely until in-person testimony can be obtained? So as you know, my thoughts on it are, I think it makes sense to do video. Depending, if it's a major case, then I can understand, trying to get continuances when credibility is at stake. So in this particular case, recall that there was they started doing the remote case in chief trials in May. And then in August, in this case, August 20th, the judge asked if either party objected to proceeding remotely. And the defendant objected. And so the WCJ issued an order continuing the trial to allow for in-person testimony. So oh, I'm sorry, I said this was unbanked. This was a significant panel. This was a significant panel decision. So this actually wasn't binding, but it's got a lot of persuasive value. The court held, in fact, this is the one where I told you there was no significant panel decisions last year. This is the first one this year, so we already got one. The court held that trials should proceed remotely absent case-specific facts requiring a continuance for in-person testimony. So essentially, the 7 members all agreed that this case posed a very significant issue, something important that they needed to give us guidance on. And so they declared it a significant panel. And they said that trials should proceed remotely unless there's a very special situation. I'm not exactly sure what that special situation would be. I really don't know, but that's what they said. So the reasoning was that the governor's executive order suspended all statutes and regulations requiring in-person hearings. So we have to be able to move the cases. Also, the California Constitution requires the efficient, timely resolution of disputes. So it's very clear that it could be a violation of due process if either side is unable to get a decision on the merits of their case. So I get it. I see what they're doing here, and as I've become more comfortable with it, I'm actually in agreement with it. They also pointed out that the labor code anticipates and permits an informality in proceedings when it comes to workers' compensation. So ultimately, that's the way it's going to be. I don't see this being challenged. I'm not aware that it's going to go up to the appellate court or further. And this is how it's going to go for right now. So the next case is Williams versus Chino Valley Independent Fire District. And this was a panel decision, so it's not binding. And the issue is whether defendants can deny medical treatment for a non-industrial condition after it has been approved by UR. So in this particular case, the applicant had an industrial skin cancer claim. The PTP treating the applicant issued a request for authorization to treat varicose veins, which doesn't sound to me like it's related to skin cancer. The adjuster sent it to UR, who approved the treatment. The defendants then further developed the record, and after the PTP was unable to prove the varicose vein treatment was related to the industrial skin cancer, they didn't want to pay it. They denied the treatment. So the court came in and they held that the defendants must provide treatment approved by UR. And the reasoning was that the defendants may dispute whether treatment is for an industrial related condition using the QME process before submitting the treatment to UR. And so what that means is they should have gone and objected to that treatment, whether the varicose veins were related to the work injury, by going through the QME process rather than sending it to UR, because once they send it to UR and it was approved by UR per 4610, it cannot be challenged. So this is not a binding decision, and I've seen a number of cases like this where it's been sent to UR just as a backup, but it's on a denied condition that they just want to make sure that they've covered their bases. And so you got to be careful if this case, although it's not binding, if this case ends up being the law of the land, you may lose your defense on that particular body part in treatment because you send it to UR who approved the treatment. So that's something a pitfall to be wary of. All right, so next case. This pertains to compensable consequence psych injuries. This was an interesting case. It's a panel decision, so it's not binding. But the applicant was prescribed an analgesic cream for pain, and so the applicant put it on her body, and was treating her pain, and she had a baby, and I don't know exactly how, but maybe as she was holding the baby and had the cream on her body, maybe the baby like sucked on her arm or whatever it was. But somehow the infant son ingested the cream. She ended up bringing a psych claim, and the QME found that 70% of applicant's psych injury was caused by the child's death. So the question is that 70% a compensable consequence of the work injury, such that the child's death, even though it's clearly sounds not related to work, is that psych injury resulting therefrom compensable? And the court found, wait for it, yes. The psych injury was approximately caused by the treatment and not by rashly taken activity. So the reasoning was that subsequent injuries are compensable consequences when they're approximately caused by 1, the original industrial injury, and 2, not rashly taken activity. And the court found there was proximate cause because the cream was prescribed to treat the injury. It was pain cream. And it wasn't rashly taken because the applicant had no clue that her child could get ill and certainly not die from if the child got the cream in their mouth or ingested it somehow. So this was a non-binding panel decision, but it gives you an idea of where it would go. And I kind of see it. It's kind of a crazy case, but I do see how the connection is there. All right, next we've got a case of Nelson versus SP Plus, and this pertains to whether there's a bona fide offer of work. And here the issue is, did the employer make a valid bona fide offer of work to the applicant? And here the applicant had an injury and was released to work with a sedentary work restriction. And so the employer wanted to accommodate the restrictions. And so they sent a text to the applicant, and it said, hey, come in next Tuesday and Thursday. But it didn't indicate what the job was that was going to be done, the duties, things of that nature. The applicant didn't show up for work, and so the defendant disputed liability for TTD. This was also a panel decision and non-binding. And I apologize that I keep moving my camera because my information is blocked due to not knowing how to use this program that I'm on right now. The court said no, the employer did not make a valid offer of work to the applicant. They said that the text message was not a valid offer because it didn't give the description, the duties, whether it was within the applicant's work restrictions. It was just a text saying come in on Tuesday and Thursday. And then the applicant's counsel was able to get the supervisor to testify that they intended to offer the work after meeting with the applicant. So technically it wasn't even an offer because they were going to meet with the applicant and then make the offer after they spoke with the applicant. So that was a very good job by the applicant's attorney to get that kind of an admission because it essentially, I think, won them the case. All right, so the next case is an en banc decision. So this is binding. Here's an en banc. The issue was whether applicants entitled to a voucher despite ineligibility to return to a prison job due to being released from jail. So you have someone who was in prison, they had a job in the prison, and while they were doing that job, they had an industrial injury, and they were working as an inmate laborer. The applicant was ultimately released from prison, and he was declared MMI afterwards. The defendants, they sent a letter indicating that they could make a bona fide offer of work, except for the fact that he voluntarily resigned. And so their argument was essentially, by leaving prison, he voluntarily left his position, so we shouldn't have to make a bona fide offer of work. The en banc decision resulted in a holding that the applicant was statutorily entitled to the voucher despite ineligibility for the old job due to the release from prison, which to me makes perfect sense. Obviously, he's not going to go back to prison so that he can do a modified job. You want to get as far from prison as possible. And so the WCAB recognized that the prison was precluded from making a bona fide offer of work. However, they still felt that only an offer of work relieves employers from providing the voucher. And since no offer was provided, the voucher is something that the applicant was entitled to get. And again, this is an en banc decision, so I don't anticipate this rule changing. I think it'll end up being something that we follow. I'm not aware that this is being challenged. The date of this decision was, I don't have the date, but it was in 2020. Next case, Morgan versus Living Spaces. This was decided on August 18th. It's pertaining to voucher eligibility after a resignation. And the issue is whether applicant was entitled to the voucher despite resigning from their position. In this case, the applicant resigned from her job 4 months after sustaining an injury. Over a year after resigning, the applicant was declared PNS and released with permanent work restrictions. Defendants argued they didn't owe a voucher because the applicant resigned. Now, this was a panel decision as well. And the panel held that the applicant was statutorily entitled to the voucher despite resigning, and they relied on the Dennis en banc decision that we just covered. The reasoning was that applicants are entitled to the voucher where the applicant is permanently disabled, so you've got some PD, and the defendant does not offer qualifying, regular, modified, or alternative work. So the resignation didn't affect the employer's obligation to make the offer, and therefore the voucher was allowed. And yeah, that's perfectly consistent with the Dennis case. So it's all about whether in fact an offer was made. All right, next is gun. This is a California Supreme Court case. It's probably not going to be relevant to many of you. The reason I included it was I just wanted to have a California Supreme Court case because, as I indicated earlier, it's the law of the land. So everybody has to follow this. The only way you're going to overturn this case is because the California Supreme Court case changes their opinion, or maybe legislation comes out that changes it, because the California Supreme Court, they're going to interpret legislation. They're not going to create it. So the issue here was pertaining to the exclusive remedy rule and whether the rule applies to bar the gun civil claim. It's a very interesting case. The police received a 911 call from a female, and she whispered, "Help me," into the phone. And so the police didn't think that there was any kind of danger, so what they did was they contacted the Guns, which were the neighbors, and they deputized them to go check on the neighbor who called in and tell them whether the problem was whether there was a problem, but they thought it was likely due to bad weather, so they weren't suspecting anything significant. The Guns, they go next door and check on the neighbor, and they get injured by the neighbor's murderer. So that neighbor was actually being murdered. The Guns escaped, and then they filed a claim against the police. And so the question presented is whether the exclusive remedy rule barred the civil case. And the court ultimately decided, the Supreme Court ultimately decided, that yes, the exclusive remedy rule applies and bars the civil claim. The reasoning was that the California Labor Code provides anyone assisting a peace officer is deemed to be an employee of the public entity. So once they deputized the neighbors, the Guns, they were now employees and of the public entity, and therefore, if they were injured doing the duty that they were requested to do, then they get a valid workers' comp claim. So they had an employment relationship with the County of Trinity. The injury was therefore industrial cause and subject to the exclusive remedy rule, and civil case is barred. All right, I think this is the last case. It's actually not a case, it's an order. It's an en banc, and it was issued on December 15, 2020. And it's the suspension of WCAB Rule 10789C, which pertains to walkthroughs. So on March 17th, the DWC closed all of its district offices. That's when the order came down by the governor. Then they reopened on April 13th, but they weren't doing walkthroughs. They were not permitted, and the judges were working remotely. And then on December 3rd, things obviously opened up some, and then we started doing various types of hearings and video hearings and things of that nature. But we still weren't doing walkthroughs. Then on December 3rd, California Department of Public Health issued a regional stay-at-home order based on ICU capacity, and that's where the governor had the 5 regions, and we had the Southern California region, which I'm in Ventura County, and it went all the way, it went above us, and then it went down to San Diego, huge region. And so there were the 5 regions, and it issued a stay-at-home order based on ICU capacity. Then on December 15, WCAB commissioners voted to unanimously suspend Rule 10789C. So what is 10798C? Well, first you got to look at 10789A, and that permits the submission of certain documents on a walkthrough basis. And the most important of those is a compromise and release. It was always wonderful. We could settle a case and go the same day or the next day and get it an OACR disposing of the case, which was wonderful, particularly at the end of the year when we're in that end of the year push and tons of CNRs are being completed. And we want to get them all done so they can get paid before the end of the year. So it's always been very important, but this year we didn't have that opportunity. It was brutal, and you didn't know who you were being assigned to, and you would get set asides. It was by far the hardest year we've had when it comes to getting OACRs done on a timely basis. So on December 15th, this in-bank order did away with 10789C, which provides rigid requirements that each district has to follow to comply with the walkthrough cases. And it says like they got to have someone available for walkthrough from 8:30 to noon and 1:30 to 5, and they have it has all the requirements. Well, they don't have those requirements now. Pursuant to this in-bank order, the WCAB suspended subsection C in order to permit district offices to schedule walkthroughs based on their capacity, which makes sense. But they also indicated that the judge can assign, decline, prioritize walkthrough documents as they see fit. Now, it sounds like this wouldn't be a good thing, but the fact is they're now doing walkthroughs. So we weren't even getting to do walkthroughs, but now we've just been able to get some walkthroughs done where you appear on video with the judge who's scheduled for those walkthroughs, and you appear and you talk to the judge, and it's as if we're in the same room with the judge. Everything gets done, although we didn't have to drive there, which is very nice. The fact that we've been avoiding being on the roads, and for me, having 17 attorneys driving all over the place is something I've never been very fond of. So this video has been great because it takes away the risk and that liability. So we've been able to get some CNRs walk through, talk to the judge, get the order, get it all taken care of, more like before, even though it's not in person. So I think things are gonna start improving, and hopefully all the boards are doing this. I know some of them are because we've appeared before them. So this is actually a good step in the right direction. And that does it. Let's see, what, 10:56. So I think we did good on time.
Great job on time. Great job. I don't know if you can hear me. I don't think you're going to be able to see me. I think we're disconnected, James. I'm sorry about that. But
I hear you.
Oh, fantastic. All right. So I just wanted to bring up a few things for everybody. Just a reminder, your email will have your certificates for you. We have upcoming Macro Pro and Friends that are in the works. I want to show you. We've added them to our website. So now you could go on to macropro.com and look at all the topics of all the upcoming events and click onto them and register for that. I do want to urge you that tomorrow we have a really important webinar that we're going to have, and it's on finding your new norm. We are almost 1 year into this COVID, but norm is far away from what we have seen in the past, and we want to make sure that we help everybody with that. We have Dr. Deborah Tall that's going to be speaking to us on that particular topic. So please invest 45 minutes into yourself tomorrow at lunchtime. Register for that at macropro.com. James, I'd like to thank you so much for the masterclass on what happens with the courts and how things work. I really enjoyed the way that you started that presentation and explaining how the courts work and when decisions matter and when decisions don't matter. And of course, your expertise on everything else is greatly appreciated. All right, everybody, until next time, we'll see you at Macro Pro and Friends. We'll talk with you later. This is Diane Cohen, and on behalf of Macro Pro, we thank you very much for joining us. Bye-bye now.
Bye.